This is a training for mandated reporting child abuse. We will review mandatory reporting laws for child abuse and clarify TD3 child abuse reporting protocol. Child Protective Services' primary objective is to keep children safe within their own families. The program tries to balance the legal rights of parents and the needs and rights of children to live in a physically and emotionally healthful situation. Protecting the health and welfare of students is the most important and fundamental responsibility of every professional educator. As a school employee, you play a major role in keeping students safe. The mandatory reporting law requires all school personnel and other persons having the responsibility for the care or treatment of children who develop the reasonable belief in the course of their employment that a minor is or has been the victim of physical injury, abuse, child abuse, a reportable offense or neglect that appears to have been inflicted on the minor by other than accidental means, or that is not explained by the available medical history as being accidental in nature, or who reasonably believes that there has been a denial or deprivation of necessary medical treatment or surgical care, shall immediately report this information to a peace officer or to Child Protective Services, except if the report concerns a person who does not have care, custody, or control of the minor. The report shall be made to a peace officer only. Every school has a coordinator responsible for assuring that all school personnel are trained in the identification of abuse or neglect and their role in reporting. The school coordinator is a resource person who can provide support and information to mandated reporters who encounter a potential abuse situation. In TD3, the school nurse or school counselor serves as the CPS site coordinator. After this training, please contact your site administrator to find out the name of your CPS site coordinator. Those made aware of the possible abuse must make the report directly to CPS. Reporting suspected abuse to one supervisor alone will not satisfy the requirement. If it is unclear what should be done, the best policy is to report the allegations to the proper authorities. You play a very important role in keeping children safe. You are mandated by law to report abuse. You have a great deal of contact time with children. You may be the first person to observe the abuse. You have a relationship based on trust, and therefore a child may choose to disclose to you. TD3 requires mandated reporters to call both law enforcement and CPS. Mandated reporters do not have to have proof and are immune from liability if they make a report in good faith, even if CPS is unable to substantiate the report following an investigation. Mandated reporters who fail to make a report could be held criminally liable for not following the reporting laws. A person who violates any provision of this section is guilty of a Class 1 misdemeanor. If the failure to report involves a reportable offense, the person is guilty of a Class 6 felony. This could subject an educator who fails to make a required report to a misdemeanor sentence of up to 6 months in jail and a fine of as much as $4,000, or if a felony, a sentence of up to 1 year and a fine of as much as $150,000. Being sued for a failure to report abuse is a real possibility if a perpetrator later injures the same child again or harms another child. You are required to report allegations of child abuse from a third-party disclosure. You should not tell parents that CPS has been called when allegations have been made that the abuse took place within the home. Doing so may cause several different reactions by the parent. These include coaching the child about what to say when interviewed, threatening the child to not tell of abuse, or hiding the child from authorities so his or her safety cannot be assessed. Most importantly, the child may be placed in danger by a parent who is a perpetrator. The major categories of abuse and neglect to which CPS responds are physical abuse, which includes the infliction or allowing the infliction of a physical injury to a child. Physical injury includes skin bruising, pressure sores, bleeding, burns, soft tissue swelling, bald patches where hair has been pulled out, bite demarcation, and welts such as from cords or other objects, and the following items which require medical diagnosis: failure to thrive or pediatric undernourishment, malnutrition, dehydration, subdural hematoma, injury to any internal organ, or any physical condition which imperils a child's health or welfare. A determination on whether or not an injury is accidental versus non-accidental is made by looking at a variety of factors, including the location of the injury, the size and shape of the injury, the number and ages of the injuries, the age of the child, and the history provided regarding how the injury occurred. Sexual abuse is defined by the National Center for Child Abuse and Child Neglect as the involvement of dependent, developmentally immature children and adolescents in sexual activities that they do not fully comprehend, to which they are unable to give informed consent, or that violate the social taboos of family roles. Some possible indicators of sexual abuse are pregnancy in a young child, sexually transmitted disease, frequent infections, sexualized play in young children, promiscuity, nightmares, or insomnia. Emotional abuse. Emotional abuse occurs when a child displays inappropriate aggression, depression, withdrawal, or severe anxiety, which is diagnosed by a psychologist or medical doctor as being caused by the acts or omissions of the child's parent or caretaker. Emotional maltreatment includes blaming, belittling, or rejecting a child, constantly treating siblings unequally, and persistent lack of concern by the caretaker for the child's welfare. Speech disorders, lags in physical development, and failure to thrive syndrome are physical indicators of emotional maltreatment. More often, it is observed through behavioral indicators, and even these indicators may not be immediately apparent. Neglect. Neglect is defined as a child not receiving necessary care or treatment to keep them safe and healthy. Neglect includes the inability or unwillingness of a parent, guardian, or custodian to provide that child with supervision, food, clothing, shelter, or medical care if that inability or unwillingness causes unreasonable risk of harm to the child's health or welfare, except if the inability of a parent or guardian to provide services to meet the needs of a child with a disability or chronic illness is solely the result of the unavailability of reasonable services. Neglect includes permitting a child to enter or remain in any structure or vehicle in which volatile, toxic, or flammable chemicals are found or equipment is possessed by any person for the purposes of manufacturing a dangerous drug. Additional examples of neglect include deliberate exposure of a child by a parent, guardian, or custodian to sexual conduct or contact. Confinement means the restriction of movement or confining a child to an enclosed area and or using a threat of harm or intimidation to force a child to remain in a location or position. Abandonment is defined as the failure of the parent to provide reasonable support and to maintain regular contact with the child, including providing normal supervision, when such failure is accompanied by an intention on the part of the parent to permit such condition to continue for an indefinite period in the future. Keep in mind that parents have the right to allow another capable adult to parent their child. Non-sexual exploitation is defined for CPS purposes to mean the use of a child by a parent, guardian, or custodian for material gain, which may include forcing the child to panhandle, steal, or perform other illegal activities. For additional information about the types of child abuse, please visit the Arizona CPS website. A report should be made when any person who reasonably believes that a child under 18 has been physically, sexually, or emotionally abused, neglected, exploited, or abandoned. Any person who reasonably believes that a minor is or has been the victim of one of the items listed on your screen must make a report immediately. If additional incidents of abuse occur after the initial report has been made, you must make another report. It is important to remember that the individual making the report must only have a reasonable belief that abuse has occurred. More specifically, if there are any facts from which one could reasonably conclude that a child has been abused, the person knowing those facts is required to report. However, please note, a report of suspected abuse, neglect, exploitation, or abandonment is only a request for an investigation. The person making the report does not need to prove or investigate the abuse. Investigation and validation of child abuse reports are the responsibilities of child protective service workers. Clearly visible signs of abuse, such as bruising and a child's report of abusive conduct, trigger the requirement to report. An oral or written disclosure by a child can also form the basis for reasonable belief. Other circumstances may be less clear, but always keep in mind the discretionary reporting provisions. Reports that may not come from direct visual observation may still be made based upon a reasonable belief that a minor is or has been the victim of abuse. Reports should be made immediately to the local law enforcement agency and Child Protective Services by phone at 1-888-SOS-CHILD. This report should be documented on our CPS reporting form and filed in a confidential location by your site CPS coordinator for our records. Reports should not wait until the end of the day to be made. Each site should have a process in place to cover a teacher's class, so reports take place immediately. The word immediately must be read literally in this law. Any delay, any failure to personally and immediately report or cause reports to be made based on unfounded assumption that someone else, at the educator's direction or otherwise, is reporting and doing so immediately, and that another person's report satisfies the educator's reporting obligations, has been viewed in some instances as a violation of this law and can subject the educator to criminal prosecution for such failure and possible civil liability if a delayed report or mistaken failure to report leads to harm to a child. It is a difficult decision for a child to decide to disclose abuse or neglect. Therefore, it is critical for you to be careful in your interaction with the child, should you be the one they decide to disclose to. It is important to follow these rules. Provide a safe environment. Make sure the setting is confidential and comfortable. If you are outside with the child, walk away from the other children and toward another adult to protect the child's privacy. Listen. Don't make assumptions. Use reflective listening. Don't put words in the child's mouth or assume you know what they mean or are going to say. Make no promises. The child is fearful of many things. They could get taken away from their family. The person who hurt them could go to jail. Their parent will be angry with them. All of these things could happen. Don't tell the child they won't. Also, don't tell the child that you won't tell anyone what they tell you. As a mandatory reporter, you have to tell. Document exact quotes. Don't write what you think the child meant, and don't summarize. Write what the child says, even if they are using slang or unpleasant language. Be supportive, not judgmental. Even though the child is disclosing terrible things that may have happened to them at the hands of a loved one, the child still loves that person. Don't talk negatively about the family, and don't show shock or anger in your body language. In order to reduce additional trauma that happens to children during the investigation process and to increase the likelihood of successful prosecution, all mandatory reporters should limit their questioning of children who have disclosed abuse or neglect. These 4 questions: what happened? When did it happen? Where did it happen? And who did it? Are designed to accomplish 2 things. The first is to give the mandatory reporter parameters on how to gather enough information to determine whether or not a report to CPS and law enforcement needs to be made. The second goal is to assure that leading questions are not asked. This could compromise the ongoing investigation. It is important that the person the child initially begins to disclose to be the one that finishes the interview of the child. Never stop a child in the middle of their story and ask them to tell it to the nurse, principal, etc. The child chose you to disclose to. If they wanted to disclose to the nurse or principal, they would have approached them first. We want to minimize trauma by minimizing the number of people who ask the child questions. To make a report, call toll-free 1-888-SOS-CHILD, 24 hours a day, 7 days a week. Language interpretation is available for over 100 dialects. When you call, a hotline specialist will ask a series of questions and determine if the information meets the criteria of a report, including the nature and extent of the abuse, for example, size or color of any injuries, when the child was last seen and current condition of the child, actual statements made that indicate abuse or neglect, the child's name, date of birth, current address, and phone number, parent or caretaker's name, address, and phone number, non-custodial parent's name, address, and phone if possible, names and dates of birth of other children in the home, current school child attends, any other information that the person believes might be helpful in establishing the cause of the abuse. Relevant medical information must be revealed to CPS. This would not be viewed as a violation of FERPA. You will be asked your name and phone number, but anonymous reports will be taken. You will be advised if the information meets the criteria of a report. Mandated reporting sources are no longer required to send in a follow-up written report after making the report by telephone to CPS. However, in TD3, the written report is required to be completed for each CPS report made and kept on file with the site CPS coordinator for documentation purposes. A copy of the CPS reporting form is available from your site CPS coordinator and as a link on Epic, our employee website. Take a look at this list. None of these items would trigger a CPS report. Arizona has no laws allowing CPS to intervene in families who are not sending school-age children to school. This is a law enforcement matter only. CPS has no authority to investigate or monitor court-ordered divorce, visitation, or custody matters. Unless a child has suffered or will imminently suffer harm from their parents' or caretakers' actions or inactions, CPS has no authority to intervene in a parent's lifestyle choice, such as a dirty house, lice, or poorly dressed children. Sometimes personal choices are not in line with our own. They may be different than our own due to cultural differences. CPS respects the right of a parent to choose how they want to live and how they want to raise their children. CPS has the authority to intervene only when the choices the parent makes places the child in danger. Frequently asked questions. How do we handle medical neglect issues? What is the line or threshold for a report? You should not consider a line or threshold. As the reporting statute states, if you have reason to suspect abuse or neglect, you are mandated to report. Let the hotline determine whether it meets the criteria for a report. That being said, the two descriptors used by the hotline that may apply to medical neglect read as follows. Neglect, high risk. Delayed or untreated medical condition which is life-threatening or permanently disabling, which may include comatose state or debilitation from starvation or possible non-organic failure to thrive or neglect resulting in serious physical injury or illness requiring emergency medical treatment. Failure to use child restraints are not reports. Low-risk neglect includes delayed or untreated medical problem, causing a child pain or debilitation that is not life-threatening, and parent, guardian, or custodian is unwilling to secure medical treatment. Are CPS reports confidential? CPS reports are confidential, but they can be released under certain circumstances. The person about whom the report is made can have a copy, but the source information is redacted. CPS provides law enforcement agencies with reports as well, and prints a police version in which the source name is removed. However, police reports are public records and can be obtained by others. If you have questions regarding confidentiality, please discuss them with your CPS site coordinator. Can CPS workers speak with us regarding specific cases? They can speak to you to acquire any information needed to complete their investigation. They can only share information with you if it is necessary for the safety of the child. If a CPS caseworker needs to interview a child on site or review an educational record, they can do so without parental consent if it is necessary to protect the safety and/or welfare of the student. The caseworker should present identification and signed forms stating their right to this access upon arrival at the school. Copies of what these forms look like are available from your site CPS coordinator and school administrative assistant. Should we examine a child's injuries? What if they are in private areas? If the injuries are noticeable without removing clothing or can be seen in the normal course of exposure to a child, you should examine so you can report what you see. As for private areas, this is better left to CPS and appropriate medical personnel. TD3 does not allow nurses or health assistants to examine private areas. An exception to this would be caretakers who are responsible to change a child's diapers, who, in the course of their normal care of the child, would see a child's private areas. Who can be told about the abuse? For example, should the nurse, teacher, counselor, or psychologist know? The child abuse coordinator and building administrator should be informed. The TD3 crisis line should be called. Information should be limited to who really needs to know to keep the child safe. Finally, the person required to report only needs to reasonably believe abuse has occurred. Upon developing a reasonable belief, reporting is required immediately by telephone or in person. When a child discloses information about abuse, ask 4 questions: what, when, where, and who. The legal duty on each required reporter is to personally immediately report or cause reports to be made. Thank you for your time and attention during this training. Please see your CPS site coordinator if you have any questions.